G'day Nina, how are you?
Good, thanks Andrew. How are you?
Well, we've got a lot of technology around us today, haven't we?
Yeah, technology seems to be the flavour of the month.
But we are achieving through it. Interesting. I've just done a interview for Lawyers Weekly talking about the impacts of artificial intelligence on law, but it really applies across all business practice, professional services, isn't it? Because we're seeing the digitalisation of all transaction work, whatever service you come from. And so accountants, lawyers, a whole lot of people are, for those who deal in the transactional space, losing their relevance. And for us, we have these terrific tools, but we've also got clients out there who are utilising those tools. One of the questions I was asked is, will there be more litigation as a result of clients being better informed? And my answer, and it is the correct answer, is no. Professional litigators are people who understand risk and they measure that risk and they trust their advisors, but we'll see a surge in self-represented plaintiff litigation of people who go into ChatGPT, find they've got a case not understanding its Spanish law, and then come and run it.
Yeah, I think that's the key difference. At the moment, AI is not advanced enough in order to do the critical thinking part. It can definitely give you like what it perceives to be the facts and things like that. But until it gets to that next stage, I don't think we're irrelevant yet.
No, and I think actually the advisory part of what we are will always be relevant, but AI will be a wonderful tool for us and for our clients to go and say, oh, I understand why you're doing that.
Yeah.
Anyway, look, let's go to the first case today. Nina, we've got a Liberal government in Queensland who's decided to press pause on anti-discrimination legislation passed under a Labor government with a majority in the House.
Yeah.
And they've said they need to push it back because they want to do greater consultation.
Yeah, so it was supposed to come into effect from 1 July, but with the backing of the State Attorney General, they have officially paused it because they're concerned about potential adverse outcomes due to the expansion of things like what are the protected attributes. So I think it's going to cover things like irrelevant medical records, irrelevant criminal records, personal appearance like we have in Victoria, and also homelessness. Yeah. So they're saying that based on their review, the Labor government haven't done enough, which is ironic because I read an article today that said it took years in the making to get here.
Oh no, it's just nonsense, isn't it? We're sort of in a Trumpian world where there's
It does feel like that.
Where there's sort of any political party that comes in, Labor, Liberal, whoever it is, comes and resets an agenda and says, oh, not enough. Can I just say, in the discrimination world, Victoria's been the only place where physical appearance has been a protected attribute in Australia. It is a fantastic protected attribute because we know you sit in a restaurant, if you're like Nina and I, and you watch people come through the door and you whisper to your partner things you should never say about the person who came through the door, and then you realise that level of judgment is something that's done between people who love each other, but it forms part of everyday perception and how people are managed. I don't think there's enough people who think deeply enough to say, in this world of increased perfectionism, things which are not perfect will become negative measures against people. And therefore there is a need to force reflection upon decision makers as to what are the merits of things rather than what are the perceptions of things. But look, the other difficulty I think we're experiencing in all jurisdictions is everyone is making it up as they go along. So we've got, WHS legislation, Victoria OHS legislation. We've got positive duties by respect at work. And then each state are putting another layer on the onion, whether it's through safety law, whether it's through discrimination law, to meet their own state-based driven policy. And I think it's just really disappointing that Australia as a country can't get together and agree on what is basically something good.
Yeah.
And the compliance cost of getting through this stuff. So when we look at this type of issue in Queensland, in Victoria there'll be reporting that comes under the new code and regs every 6 months. We've got ACT that have the sexual assault reporting obligations which look like they're introducing discrimination-based ones similar to Queensland. Can you see how this amalgam, Nina and I live in a world of about 60 pieces of legislation, but that wasn't so bad where most of them lined up.
Yeah.
But what we're now seeing, and we're even seeing a push in anti-bullying jurisdictions to say before someone can bring a workers' compensation claim they have to have lodged anti-bullying. It's just such nonsense as people try and avoid responsibilities of being good to people and different organisations or different parties press a button to save money here or to do something. Workplace law is about actually ensuring that workers are treated fairly and that workers behave well. That's it.
Yeah.
It's not hard.
Yeah.
But it's being made hard every day by these little colours that are added to everything, and then we get a party that come in after years and years of consultation and go, I don't think I like it.
Let's rip it all up.
Let's rip it all up. Why don't we have a look at the same job, same pay? Nina, talk to me about this.
Yeah, so this was an application by the Mining and Energy Union to make sure that the labour hire workers got paid the same as the workers at the Bengala mining company. But I think we had a discussion about this, and it was quite a weird case, very unique set of facts.
Well, it's weird, but can I just say this? It's a pretty dumb argument to run a case saying, look, we pay people extra money to set off something, therefore they shouldn't get a higher base rate based on an enterprise agreement. Now, there are different types of employees that are provided by Skilled, who were the labour hire provider, to the mine than sat under the enterprise agreement. But the nonsense argument and the same job, same pay rule is, if I pay you a global amount for working a number of hours, which is quite high, but which, had it been paid at the base rate, would be higher, that somehow that's unfair.
Yeah, that just doesn't
And
make
that's sort
sense.
of where we land with this case.
Yeah.
And not surprisingly, although there'll be some anomalies with this, the Fair Work Commission, which is the full bench, just looked at it and said, this really is a nonsense argument.
Yeah, but I feel like the other argument was very weird though, because this enterprise agreement only had annualised salaries. So really it had only contemplated full-time workers. And the labour hire workers were included part-time, casuals, and also floaters. So it did not contemplate those kinds of arrangements. But because they now have to apply that, there will be workers who are getting paid higher rates that incorporate things like overtime, leave and things like that, which they're not entitled to.
Except for this.
Which they acknowledged, and they were like, oh, but it's fine.
But the difference is all the host had to do is come back and say that the annualised wage is made up with a base rate of this and multiplied through, and the whole thing fell away.
No, but I think even with the multiplying, they're still getting things that are incorporated in there, like overtime, which they haven't worked.
I think there was an argument at the end of this, had it not been run in such a contentious manner, which would basically say, look, the base rate under the enterprise agreement in an annualised wage, as an element of it is this, and that should apply for casuals and part-time. If that was run, then I don't think this argument would be anywhere near it is. But what's happened is we've had a contest where people have got caught up in hyperbole and they've missed the big picture. Really, that's where I think we've got to.
Well, the real winners are those workers. I think each of their salaries is increasing by $50,000.
Well, some of them. Can we talk about this jurisdictional argument that came up in Kellyanne Malolis and the Australian Ears Hearing Care?
Yeah, this was a silly argument. Shall I?
Yeah, no, you get on with it.
Because it's one of the ones I summarise. So essentially, she worked for the Australian Ears and Hearing Care, and they weren't doing very well financially. So
She's got a $100,000 pair of ears, though.
Yeah, that was so weird.
Can I just say, who's got a $100,000 pair of ears? I mean, mine might weigh $100,000, but
yeah, that was like a separate part of it. But basically, so I will talk about that because that was very weird. So essentially, she demanded this bonus of $130,000, and they said, no, we paid you the money already. You're not getting extra money for the photos of your ears.
Tattooed ears.
Yeah, and we're going to use it forever and we own it for life is what they said. Very weird. But anyways, essentially they sent her an email saying, we're going to terminate you within probation because we just can't afford it, but we'll offer you a casual role from like a week after your termination. She didn't accept the casual role and filed a general protections claim, but they said she was out of time because she she was paid up to the date that she was given notice, but they'd said in that email, we're giving you 1 week's notice, and just conveniently didn't want to include that.
Which takes you to the casual.
Yeah. So it was just silly.
Well, I think, look, there's a reason I wanted this case, just part of the reason because it's the silliest case I've read all year.
So
but
silly.
partly was because employers forget when you create documents, they are the best evidence.
Yeah.
And the best evidence here reveals that it wasn't out of time.
No.
Because you'd actually said you got 1 week's notice,
Yeah.
and that means you finish on the end of the notice, and therefore you're within time.
And other emails where you acknowledged that her termination date was the 26th, which was a week later. Like, silly.
So I put it in because I just thought how often you and I receive a bunch of emails and letters that have gone, and people's narrative over a period of time, because they're feeling offended, annoyed and angry, falls upon a set of facts which is not borne out by the documents that sit beneath it. So when you get to stage and you think, look, I'm about to press the red button which says termination, can you just go back and read your emails, read your documents and go, okay, so what are the facts that fall out of this that are germane to the termination process? Because if they had have done that, we wouldn't have this case. Now this case has a really red hot go of being successful in GP world because it's emboldened the plaintiff in the case, the applicant, because they've won the first round.
Yeah, well, I think that should be another point as well, is that yes, you've got the ability to mount jurisdictional objections, but you should only use it if you actually think you've got a good grounds to do so, because it goes to hearing straight away. Like, you basically skip the conciliation, you go to hearing, which is an expensive and resource heavy process. Why would you run it if you don't have a chance, especially with the running out of time one when it was clearly the opposite?
Look, the other part of it is, when somebody tastes victory, they don't let go.
Yeah.
So, think twice about it. Enforceable undertakings, Nina, are something you and I rail about too often, and here's a case where somebody was involved in a second injury for an organisation where they end up giving a $925,000 plus enforceable undertaking for a hand injury. Yeah. This is Cleanaway Operations, the case. The facts are a bit all over the place because there was this injury, subsequently there was a fire at another site. Yeah,
that was a major fire and they got fined $300,000 and I think that's why they tried to enter an enforceable undertaking, because they were worried. There was a lot of focus on them because it was a major fire. But $300K versus $925,000 minimum.
And the major fire is one which could have caused loss of life. This is one which is at most could have caused amputation. Oh, no, that's bad, but
because it was a lack of guarding, so it was something easily fixed.
Yeah, so odd decision, and let's just talk why we suggest enforceable undertakings, which doesn't often happen, and why we suggest don't do them. Where it is something in the nature of your operation you're likely to injure someone again, we would never suggest enforceable undertaking. Why? Because in an enforceable undertaking, you spend a lot more, $925,000 for $100,000 fine. It's a lot more. It's 8 times what you normally pay. That's not normal, but it is, in this case, it's substantial.
And the spending is not to fix the issue. You have to do that anyway. That's on top of it.
It's about going out and actually educating and shaming, really.
Yeah, it's to do other safety initiatives. So that's not your whole cost,
Yeah, so that's one part. The second part is invariably the enforceable undertaking sets as a benchmark a performance which is commonly unachievable and beyond reasonably practicable.
Yeah.
Third, it puts the officers in your organisation and the relevant leaders in that operation at risk of jail because they are aware of what the expected behaviour is, which is a very high standard. And if there's a likelihood of further injury, after you say it's not going to happen again and we've set this process up, particularly if you fail that process, and if we use things like forklift, entanglement in machinery, those types of things, likely to happen again, then I'm afraid it's sort of dark territory and you put your officer in jail. So you spend a lot more, you create bad reputation, and then on top of that you expose your officers. Now if it's a one-off, and we've used example in meat processing with Q fever and things, which is manageable, is preventable when enforceable undertaking was given, that's great, best thing in the world. But you wouldn't do it for forklift or knife injuries in an abattoir. You wouldn't do that sort of thing because you know what the risk is.
Yeah.
So look, I thought this was an interesting case. The other major one for Comcare was John Holland, which was $1.2 million in 2022. I just want you to understand, we've spoken about previously, you can give undertakings.
Yeah.
And under Victoria, a court can direct those undertakings.
Those are the health and safety ones.
After the new reg and codes if that comes through.
Well, it's possible now, they're just not doing it. Yeah.
And then there are enforceable undertakings which are at the direction of the regulator with your your request and with the support of the regulator, which pushes off the sentencing of your matter, and after a period of 2 years means there's no conviction. So pretty good if it's for something that's not going to harm you, but if the likelihood is that another risk, another breach will arise during that period of 2 years, it's just terrible because you get dealt with more seriously for the breach, and then you have a second one on top of which you were dealt with very, very seriously for.
So we don't normally recommend them, ever.
Yeah, well, we've done one or two, but not commonly. What I thought we might do now is sexual harassment is being dealt with increasingly strongly by the Fair Work Commission, but we're also starting to see it happen. Yeah, there's no good to shake it. I was getting there. I was getting there. No, I just want to say that, when we look at bullying and sexual harassment in the Fair Work Commission, a failure in procedure will not change a termination. They've been very direct about it.
Yeah.
But what we are seeing, particularly in Victoria, is this growth of cases where the safety regulator is intervening.
Yeah.
And this is, it'd be half a dozen now in the last year. We're not seeing it so much in other jurisdictions. And so it's odd, isn't it? We've got psychological hazard legislation, codes and regs in every other state and territory but Victoria, and yet Victoria's way ahead of the other states in prosecuting psychological hazards. But I thought this was this is WorkSafe and Oz 22 painting. Interesting set of facts, Nina, but really distressing. Like it's 2025, can it still be happening?
Yeah, but I think this one was really interesting because when you hear the facts and you see the fine, I think it's a real show of how the courts consider sexual harassment, because the behaviour was things. So basically, the employee had resigned and made a complaint to WorkSafe, and WorkSafe investigated and found that one of the senior employees, so it was the director's husband, had been making comments about her appearance, inquiring about her life, trying to get her to hang out with him, and on a work trip when he was supposed to drive her to a place, kept asking her to spend the day with him and to come to a hotel room and get massages. So it was all like talking. I think once he put his arm around her neck, but not kind of like the very high-end examples of discussing sexual harassment we see. Obviously, no sexual harassment should be condoned, but based on that, and it happened over a period of 2 months,
61 days.
Yeah, they slapped a fine of $90,000 on the company.
And it's interesting, isn't it? Because if we looked at that in discrimination land, general damages for that type of non-touch sexual harassment would be $40,000, $50,000, maybe $60,000 for a concerted and deliberate process. But where there has been no, I want sex with you, let's go and have sex, where there's been no direct conversation around the sexual element, but it's been more the fostering of a relationship, you may even get general damages lower, around the $30,000 or $40,000, and that's without loss of income, I understand. But the safety regulator and the courts have said, well, in safety law, we seek to intervene and prevent this, and we will punish people through general deterrent stuff. Yeah. It's not subjective deterrent.
No.
It's nothing restorative about this. We will not accept this behaviour, and $90,000 is a big fine. Yeah, and now that employee, if they wanted to, could rely on that and bring civil claims, including vicarious liability. Yeah. So hostile workplace, sexual harassment, general protections, they're all alive during it. I think the other part that was interesting is that the individual wasn't prosecuted by WorkSafe. It was the organisation because of the lack of procedure, the lack of training, the lack of review. But so I not complying with their positive duty at all. I think that when in a year or two time he would be prosecuted. Does that make sense? Because I think this happened in like a couple of years ago, so I'm not sure if the positive duty legislation was in there for them to prosecute him specifically. Yeah, well, the positive duty still will be there on 1 December in safety. But I guess my issue with this is we're seeing safety is always thin end of the wedge. They start with the business, they expand it through to the individual. There's no doubt at all in Victoria this is a Section 25 breach, absolutely clearly. And there's no doubt at all he would be fined. And there is a risk if she had have shown any injury along the way that it could be as far as reckless endangerment. So good warning sign, good thing for training on. Yeah. What about our main topic? Nina, I want to talk about our main topic today, which is employees who surreptitiously record conversations, particularly in performance management and disciplinary proceedings. And particularly where they've been told not to. Particularly where they've been told not to. And I guess it brings us to the case of Harris and No. 1 Riverside Key Properties. interesting set of facts. At the end of the day, the set of facts aren't all that important, if that makes sense.
Yeah.
What did happen during this process was that the employee, for fear of what was going to happen, actually did record the conversation.
Even though it had been directed not to.
Even though it had been directed not to. The decision, of course, was really a different decision.
This was about out of time.
Yeah, out of time. And because there was no obvious reason for extending, that you go to the exceptional circumstances test. She said she was grieving, and that's why she didn't put it in on time. Another set of facts, not all that important. What did come out as important is what was the impact of her doing this recording. And did she publish it at all as well?
No, so she had used it in the submissions to try to be like, I've got evidence that they've not treated me very well. And what was really interesting, I felt, was the commissioner in this case said, look, I'm not required because I'm not going to grant the extension of time, but made a point to say that refusing to comply with the direction not to record was a complete breach of trust and confidence. And it was like that would have been a huge factor against her in the case had it gone all the way.
I mean, it's definitely not reinstatement, but it was but probably, and that comes from a case of Thomas and John Holland, which is not a new case, it's a 2012 case. But I guess if we look at the jurisdictions, Surveillance Devices Act lives in different types of legislation throughout Australia. I won't try and define each one of them, but except for Victoria and Queensland, it is an offence to actually record a conversation you're present in with someone without their consent.
Yeah, you have to have the consent of all parties who are present.
Yeah. In Victoria and Queensland, if you're a party to a conversation, you can record it if it's for a lawful purpose. And that lawful purpose could be, for instance, to protect your position. Okay?
Yeah.
But if you're given a direction, or there exist directions within an organisation which are lawful and reasonable directions saying you must not do it, then what happens is the lawful purpose falls away and it becomes an offence because the defence of lawful purpose doesn't exist. But it also means you go to this provision. So there's a couple of cases, just for those who are interested. There's Thomas and Nash that talks about what happens when you do this. Again, not a new case, a South Australian case which says a recording without someone's consent is clearly a breach of trust and confidence. A bit particular to that jurisdiction, but applies also to Victoria and Queensland. But undoubtedly, Thompson and John Holland goes squarely to the issue of if you have received a direction or you're aware you are not to record and you do, it goes to the relationship of trust and confidence. It's a lie, it's a deceit.
Yeah.
And therefore, it's enough to terminate of its own.
Yeah. The other part of the Victorian Queensland legislation is while you are permitted to record it without someone else's consent, if you are a party, you cannot publish it. That is a breach. And I guess what we'd be saying to employees in this situation, because it might seem like, well, then how do they get evidence? It's both parties are entitled to take their own notes of what happened, and you can rely on those contemporaneous notes.
Yeah, and look, my concern, Nina, is always this. I don't mind videoing an interview. I think it actually, after about 5 minutes, it sort of works. People relax and they start to be themselves. But it is a bit clunky, and if you want the truth from people when people are vulnerable, it's confronting.
Yeah.
I think recording doesn't capture deliberately provocative behaviour. It doesn't capture non-spoken, non-verbal behaviours. And it's also able to be edited, and even in the modern world, that editing can be quite difficult and very expensive to prove an edit did occur. So it's not necessarily desirable, whereas I find when I'm taking notes doing interviews with someone, it allows me to say, look, can you just hold for a second, can I capture that? It's a very deliberate process and quite a powerful process of collecting contemporaneous notes. So to me, it's either, this is not for investigations, this is discipline of performance. I think in investigations where people are not so much on the hook, if that makes sense, audio recording's fine, as long as parties consent to it. But my preference is always notes.
Yeah, I think that's better.
Okay, let's go to the case study, Nina.
All right. So Dirk knew he was in trouble. He had been struggling with his boss, Jan. She was trying to performance manage him, but had not been doing a good job. She would send him a list of her concerns and arrange to meet with him. He just didn't understand why she didn't come straight to him when things went wrong and discuss them. He felt he was being surveilled rather than managed. When he would come to the meeting, she wouldn't be able to say when things had happened, but would always produce a couple of documents and point to errors. At the last meeting, he asked her, why not just raise it at the time? It seems I must be doing a good job most of the time, but sometimes you're unhappy and I have to wait several weeks to find out. Then I can't remember it. She looked flustered. Jan said to him, I'm trying to be nice, but obviously that isn't working. She left the meeting and he received a show cause letter 2 hours later from Jan's boss, Brendan. Nicknamed Basher, Brendan, he was an ex-AFL player with a reputation for aggression and anger. Dirk knew he was in trouble. He felt scared and alone. He attended the meeting and sitting in front of him was Brendan and Jan. She was white and frightened. Brendan was florid and fired up. There was a policy prohibiting covert recordings of conversations in the workplace and Dirk knew it. But how was he going to prove what happened? There were 2 of them and Jan was obviously terrified of Brendan too. She would end up saying whatever he said. He switched on his phone surreptitiously and recorded the meeting. Brendan didn't take long to accuse him of various misdeeds and demand an explanation. They were not unreasonable issues to raise, including a failure to respond several times to a big client who complained and took their account elsewhere. But Brendan's manner was inexcusable. At the end of the meeting, Brendan said to Dirk, tell us why we shouldn't fire you. Dirk was so scared he just grunted, it's not fair. His employment was summarily terminated for serious misconduct. He published part of the recording on his Facebook site showing what a frightening experience it was and saying, this is what happens when you disagree with Brendan, accompanied by an AI-generated photo of a huge angry pig with Brendan's face on it. How did you come up with that last bit?
So what are the questions we've got to answer today?
So what is the effect of recording the disciplinary meeting?
What do you reckon?
Well, assuming he is in Victoria and Queensland so he can record it, it's about whether he has a lawful reason or not. And we had a debate about this because I feel like if he felt unsafe and he wanted to keep a record, I feel like that should be a lawful reason to keep it.
Yeah.
To make a record.
And there is a tension here. So Thompson's case would argue if it's used for the benefit in civil proceedings, but that's more where you're trying to deliberately record something for a benefit rather than to protect a position. Yeah. So I'm sort of with you on that part of it. I think there is a lawful purpose, so it meets both criteria.
Yeah,
so
but the publishing is not right.
Yeah, and as I've said to Nina, I've only been involved once where police have done surreptitious recordings in another state, but the likelihood of prosecution is very low. So the issue then comes as to the admissibility of evidence. And I guess that brings us to the real question of, well, now that he's done it, what can you do with it? So we've got the effect of what the recording is. It was entitled to be done because he was present and it was for a lawful purpose. The issue is what can he do with it afterwards? He's not allowed to publish it per se.
Including like publishing it as part of his case.
So the issue then is admissibility, and I won't go through the 4 tests of admissibility, but one of them deals with the issue of where the nature of the admission of the evidence is more probative than the damage of breaching the law. So in other words, where there's high levels of probative value in it, it will be admitted into evidence, okay? So if his argument was in a court, look, I was treated shockingly, there is terrible procedure, it wasn't fair, it wasn't a valid reason, it goes to the very heart of it, it's likely to be admitted into evidence without being a breach.
Particularly if he was saying that they were both lying and colluding together.
Yeah, so I just thought we'd put that out there. We'll talk more about the publication afterwards, but I think that's a really important issue. What about workers' comp claim for Dirk with what was happening with Jan all the way through?
Yeah, look, I think if he developed some kind of condition and, well, I think, linked to work because there were clear psychosocial hazards. So she was giving him feedback at the last minute, not really providing him with any clarity or direction, so he couldn't understand what was going on.
No proper risk or reward, no conversation about what's good or what's bad. So I think
no consultation.
Yeah,
really.
I think there's psychological hazards. I don't think. Yeah. I don't know if I've asked about it.
You did.
Do in the next question. Yeah, I don't think it's a safety law issue in some respects. I don't think a regulator would be at all interested in that
No.
part of it. But I think he's got a quite compensable claim, and it is the
Yeah.
very type of thing that leads people to breaking down,
Yeah.
that repetitive nature
Yes.
of undervaluing their input, of putting them on notice,
Yeah.
creating tension.
And although this is part of a management process, because it was an unreasonable way, they would never meet that threshold for that defence.
No, they wouldn't. So we'll dodge the next question, which is around safety law, because we've answered it is a breach of,
Yeah.
it's breach of primary duties unquestionably, but no one would ever prosecute it.
Will Dirk win his unfair dismissal case and be reinstated?
Good question, isn't it? Well, he's not going to be reinstated
No.
because
Breach of trust and confidence.
yeah, he's gone and done something he shouldn't have done, and then secondly, he's gone out and lampooned Brendan afterwards on social media,
Yeah.
which means no, he's not going to succeed. He's not going to be reinstated, and the dishonest nature of what he has done, along with the relevant evidence of what was wrong before, the substantial wrongs before.
But like he wasn't fired for that. He was fired for his previous stuff.
But it can be admitted in as another reason to enforce it.
Yes, I agree, but I don't know whether they would meet like the valid reason. So there were things like they said he had issues with the clients and stuff like that.
I think losing a client for failing to return a call is a valid reason.
Yeah, but the fact that they hadn't pulled him at the time they were doing it, I think, and also the lack of procedural fairness.
Well, that goes to fairness.
Yeah.
But that's
So
counteracted by Brendan's behaviour.
Yeah, I guess so. I feel like it could go.
I know it's line ball,
Yeah.
but the truth is in unfair dismissal cases, you are allowed to enter into evidence
That's true.
post facto things like dishonesty.
Yes.
And here you've got both dishonesty that you learn about, but also an attempt to wrongly publish in social media
Yeah.
things which are derogatory about your boss and your business. So
Yeah.
I think he's in a lot of trouble. But that does go to the Facebook issue because...
Yeah, so the question is, can his post be used in court? If it has the highest privacy question.
The first question is, can Brendan and Jan's business view it when they aren't members of it to utilise it in court? And that goes against Jurassic, okay? Jurassic's case is you can go and use what's in a social media site like Facebook where you're investigating a matter, and had you had to chat to the person about the post, they may delete it, therefore you can. But this is a case which is not about investigation. So it is an extension of Jurassic, which says basically, I can go and look and utilise it because it goes to the heart of the cause of the action. And if I tell the person about it beforehand, they will delete it and I can't. So yes, it would be admissible in court.
All right, cool.
I think it's an interesting case study, isn't it? And it just shows you, I think with technology the way it is at the moment, don't forget there's Keenan and a whole lot of cases that talk about employers misusing surveillance as well. So that's a topic for another day. I want you to understand from our point of view, candour and honesty about how I record things and how I do things is the very heart of trust that makes you stand well in court and stand well with your employees. Equally, when employers are dishonest, there is an abundance of law that says dishonesty is serious misconduct, including the regulations in 107. Thank you very much.
Thank you.
Great to be with you. See you later.
Bye.
Bye-bye.